Hello, my name is Maricela Alvarado. I'm an attorney here at Monty Ramirez LLP. We are an employment and immigration uh, firm. Our immigration practice ranges from employment-based to family-based and removal defense. So we do all areas of immigration, and overall, I'm here to present to you on specific on some what are the pathways to permanent residency for DACA recipients specifically? Because we've hit, an area of this program where we don't know what's going to happen next, right? So in 2023, we had a judge that actually ruled against the program, even despite President Biden's efforts to kind of implement rules that made the DACA program a little bit more permanent. But the judge decided that the new rule was not materially different from the executive action from former President Obama. So then they included that that new rule violated the APA, and so therefore the program is legal. And so now we continue to fight against this ruling, and the case is currently in the Court of Appeals. And we're still waiting an outcome there, but we definitely suspect that it's going to go into the Supreme Court, and it's likely to be heard in the Supreme Court in the spring of 2025. So what that means is that we potentially have another conclusion as to whether the program is going to stay alive, right? And the risk is that the program will end. So we have to be thinking as recipients of the document, have to be thinking about what are our pathways after this? What can I be doing now in order to secure my place in my job, my livelihood in this country? And so today I'm kind of going to go over a roadmap of what a potential process could look like. What are questions to ask yourself, to ask your family, to ask your employer, if that is an option for you, of how you can become a permanent resident. So I'm going to talk about a little bit about the different pathways, and of course, whether you're able to adjust status in the United States or whether you have to consular process and what that actually means. So in an employment-based scenario, we're going to go over what that process would look like, a timeline, and things to ask yourself, ask of your employer, and of course, going over the new Biden announcement. And then we're going to go over what the family-based process looks like. What are our options there to navigate whether adjustment of status or consular processing is a good fit? And what questions to ask yourself, what steps can you be taking in order to have a potential process? Okay, so the main thing is this: in any process to permanent residency, there's two parts, at least two parts, and that is the petition, which is whatever relationship you have, whether it's a person or an employer here in the country that can get you to the actual immigrant visa or the permanent resident status, right? So you have to have the petition and then the immigrant visa, and you have to be eligible apart from having that petition to be able to apply for that immigrant visa. And there's two ways that you can apply for that immigrant visa, which is adjustment of status or consular processing. And adjustment of status means that you're actually going to do in a process without having to leave the country. You're going to do that in the country. Consular process means you're going to actually submit an application to the National Visa Center, which is part of the Department of State, and it will require you to attend an interview at a consular post abroad. And that would mean potentially your country of birth. Okay, so what is it that we ask when we're trying to navigate, when we're meeting with a new client? What do we want to know, right? We first and foremost, we want to know, is there a process that we can take that can either adjust, where we can adjust or consular process it? And of course, the petition. What relationships do you have? And so the main question I ask is a little bit about your immigration history, your parents' immigration history. Have you or your parents ever had a petition that was filed by anyone, an employer, a family member, that was approved, and it was filed prior to April 30th of 2001? Okay, and the reason we ask this is because there's a little grandfather clause that states that if you have a petition prior to this, and it doesn't matter that you didn't adjust status or fix your status with this particular petition, but you were a beneficiary of that petition at some point, you can actually adjust status in the U.S. Because it potentially it forgives any unlawful presence that you may have had. And again, that's depending that you haven't left the country since that one time that you entered. And it forgives any employment that you've had without authorization. But it doesn't forgive any other admissibility. So like crimes, misrepresentation, multiple entries. And again, we'd have to do a full evaluation of your individual cases. But for most people, it's the unlawful entry, right? And we've been without status and potentially just working without authorization. So we get that history, but we also then look at your relationships. Do you have an immediate relative? An immediate relative is a very specific immigration term. That only includes a U.S. citizen spouse or a U.S. citizen child that's over 21. We look at other familial relationships, which includes, if you're an adult at this point, a U.S. citizen parent or a legal permanent resident parent. And for the permanent resident, to go through a process with a permanent resident parent, you have to be unmarried. And then potentially you have a U.S. citizen sibling that's an adult, or you have a permanent resident spouse. Okay, those are the family preference. So those are not considered, that's not an immediate relative status. That's a family preference category. And we'll talk a little bit what the differences are here. An employment-based is just having a U.S. employer that has provided a bona fide job offer, okay? So you have a job or an offer from an employer that can potentially sponsor you. Okay, but each of these categories have different requirements for being able to adjust status, okay? And so we have to ask more questions when we're evaluating each of these cases, okay? For an immediate relative, you have to have at least entered the country legally, okay? And it's not considering other admissibilities, but to be eligible to even consider the immediate relative category, you have to have had a legal entry, or like I mentioned, have that prior potential approval from a petition that was filed before April 30th, 2001. But for the employment-based or the family preferences categories, you have to be able to adjust status. You have to prove more than just a legal entry. You have to actually have a legal entry, have maintained your status, and not have more than 180 days of unlawful presence or unlawful employment. Okay, you have to have status at the time that you file your petition. So why does this not work for DACA, right? Even if, let's say, you've had you've never worked without authorization because you've had DACA since before turning 18 or before you got your first job, and you've had this protection. Well, DACA isn't a status, unfortunately. DACA is only a protection. It's not a status, so it doesn't meet these criteria, right? You don't start accruing unlawful presence until you turn 18. So you'd maybe not have unlawful presence because you got DACA before you turned 18, or you don't have 180 days because you got it within 6 months of your 18th birthday. And you haven't worked, but you didn't enter the country with status, and you don't continue to maintain status. Okay, so that's why this one is a little difficult. But if you have that, again, that prior petition that was approved, that you were beneficiary of, that was up before April 30th, 2001, all of this is forgiven. And that would be a reason that you could potentially adjust status in the country through an employer or through a family preference category. Of course, we have to still consider, do you have any other admissibilities, misrepresentations to obtain an immigration benefit, prior removal situations? Have you ever committed fraud in order to obtain an immigration benefit? Or maybe you have a crime that qualified you for DACA or that happened most recently that maybe would not qualify you for a permanent resident. And of course, if you have more than one legal entry in the country, I'm sorry, unauthorized entry into the country. So again, we would go through all of those scenarios of maybe there's something else that we may have missed, or that you have other than just unlawful presence or unauthorized employment. Okay, and as we talked about, if you don't start accruing unlawful presence until you turn 18. If you had DACA, then you don't have any. But let's say that you do have some unlawful presence. You either obtained your DACA protection after you turned 18, or let's say you didn't renew your DACA application on time and there's some gap between your expiration and your next approval. That time counts as unlawful presence. So it's so important to always file your DACA the moment that you're eligible to avoid any gaps, because we don't know how that can impact you down the road. So let's say you have more than 180 days of unlawful presence. Can I still consular process? What are my options in order to consular process? Okay, there is a waiver. Okay, if you have more than 180 days of unlawful presence, then maybe you qualify for unlawful presence waiver after you had your petition approved and you're ready to go on to the next step. Can you qualify for a waiver in order to be able to leave the country? To not trigger a bar. So I don't think I went over the bars, but if you have more than 180 days, less than a year, the moment that you go to the consular process, to the consular post for an appointment, you trigger a 3-year bar. If you have more than a year, you trigger a 10-year bar. Okay, so if you can qualify for a waiver, then you can leave without officially triggering that bar. You have it forgiven with this waiver. Okay. Of course, if you have more than one entry into the country, you potentially have a permanent bar. So then, this waiver does not waive that type of bar, only the 3 and the 10-year bar. Okay. And so what do we need in order to qualify for that waiver? You need a qualifying relative that is a U.S. citizen, parent or spouse, or legal permanent parent, legal permanent resident parent or spouse. Okay, so those are the only people that can help you qualify for this waiver. And you have to show that those individuals will suffer extreme hardship if you're not granted this waiver. So again, those hardships include medical, emotional, physical, economic, or country conditions in order to kind of make a claim that they would suffer extreme hardship. But if you have that option, obviously this is a great option to go, even if it's going to be a little delayed in order to finish out through either an employer or another family member. And so apart from, going through all that route of determining, okay, can I adjust? Can I consular process? Do I have a waiver option? I mean, we still have to get through the petition part, right? And so we're going to kind of go into what those petitions would look like. What are the processing times in order to actually get through that approval to you then go into applying for the waiver or going for that interview or applying for the green card directly here in the country. And so with an employment-based process, obviously you're coming to us and you're saying your employer is willing to sponsor you. And so we want to know, what does that look like, right? Obviously, this is a very employer-driven process. So the employer has to be fully on board and aware of all the legal responsibilities that this holds with it, because they are going to potentially exposing themselves just a bit in this process with the Department of Labor. They're going to be applying through USCIS and potentially, their information, once you get to that final step, potentially also the Department of State or through the consular process. And the employer has to be the one to cover the fees, especially within they cover the fees within the first 3 steps. The employee can cover the last 2 steps, but of course, what are those 3 steps that we're talking about? And here is when we actually all related to the actual perm or employment-based filing, right? Which is all mostly through the Department of Labor. So the first 3 steps are steps that we take through the Department of Labor, which includes a prevailing wage determination, which means we're submitting your job description or the job offer to them to give us a prevailing wage for your position. Then we're conducting a labor market test, which actually means recruiting for that position to prove that there aren't qualified U.S. workers for that position. And then 3rd step is actually filing the labor certification application, evidencing that we followed step 1 and 2. There weren't U.S. qualified workers, and now here's this candidate, this employee that we wish to sponsor in this process. Okay, and those 3 steps the employer has to pay the legal fees related to that and the advertisement fees. So that's step two. There's advertising fees that come involved with that, and the employer has to pay for that. So then let's say we get through that part, and that part is going to take up almost 2 years with the current processing times. But we get through that step. Now we have to file the immigrant petition. This is your actual petition, as we talked about in the first part of the presentation. This is what you need in order to start applying for your immigrant visa, your green card. In the employment-based process, there is a premium processing fee that we can pay to make this go a little faster. Once we get to this step, we can have a response within 15 days as soon as we have that labor certification approval. Okay, without it, we're going to be waiting about 7 months. Okay. And so let's say we get onto this petition. So then if we are consular processing, then we actually then begin to, we probably at this point have already discussed, do we need a waiver? Do you qualify for a waiver? We begin that process before we even get to the green card process. And right now, this is what's causing the most delays, is that it's taking over, right now, it's over 3 years. So this is what's going to take a long time. And I know that we're in we're against time right now when it comes to the DACA program. So is it possible that that DACA ends before you get through this process? Yes, but that waiver is still going to hopefully, wipe away that unlawful presence that you would then be gaining after DACA ends. Hopefully we still have it for some time before that actually happens, but that is something to consider. And then once we have this waiver, then of course you move on to your immigrant visa process. And of course, if you are one of those people that have that approval of a petition from prior to April 30th, 2001, then you go straight into the adjustment of status process. And in either one of these processes, we have to rely on what is called the visa bulletin. Every category, depending on the type of skill level your position requires, has its own category. And every category has a specific number of visas that the government actually issues. And depending on how many applicants we have for that category can mean that you'll be waiting a little longer in order to actually get to the 5th step. Okay. And unfortunately, we are in a period where these categories are a little saturated. So there is some wait time. But if you are doing the waiver, you probably, by the time this waiver is approved, you would be immediately eligible to apply for your immigrant visa. Okay. So now let's talk about, okay, I have a job, I'm a DACA recipient, I'm a good employee. Like, how do I go about getting my employer to sponsor me? So one thing is just approaching your employer, right? You might not have talked to anyone about your status at work, but it's likely they already know. You have to submit your EAD to them every 2 years to prove that you still have employment authorization. And so your EAD has a little code that always gives a little idea as to what status someone or what classification or protection that they're under. And so it's likely your employer knows, but if they're not supposed to ask you about it, right? So it's up to you to kind of bring up that conversation. So you would start the conversation potentially, your company probably already has a policy in place. So it's just looking into your manual or asking HR, what is your policy on sponsoring an immigration case, but also maybe just talking to your manager, talking to someone you trust to help advocate for you when you go talk to the HR or legal team. And this is more so in a situation where there isn't already a policy in place. If you work for a smaller company, it's likely that there isn't a policy. So you would want to make sure that you are informed in order to talk to your employer about it and to kind of explain what that process looks like, explaining to them about your status. And then, of course, you could potentially have an attorney that you can refer them to in order to help both of you through that process and helping them understand it. And then the other thing is, maybe you qualify for an H-1B visa. Maybe you qualify for some other non-immigrant visa that you can get onto while you're waiting for your green card process, right? Because we mentioned it could take years if you're doing it through an employer. So maybe we got to start thinking about a non-immigrant visa option. And so when you talk to an attorney, that is one thing that you want to discuss is like, can I switch to another status while I'm going through this process? Because if that's an option, it's definitely an option you want to take. And of course, right now, there's something new relating to potentially going to a non-immigrant visa. And this is not just for DACA recipients, but also dreamers in the country that, you know, potentially qualified for DACA, but didn't get into the program, but graduated with a U.S. degree. So this is specifically for you people with U.S. degree. And this rule technically is a rule that already existed. It's a waiver in order to have, you know, those inadmissibilities. So again, we mentioned that 3 to 10 year bar. So anyone applying for non-immigrant visa has to go to consular post if they don't already have status in the country to apply for that visa. But at the same time, when you leave, again, we mentioned those bars that you would be potentially triggering the moment you leave. So this waiver here is meant to apply to any type of admissibility that you would potentially have in order to obtain that visa status. But you still want to think about the long term. Maybe your admissibilities isn't just unlawful presence. Can this waiver overcome something that's a little more difficult, or maybe it can overcome it for this non-immigrant process, but it's not going to help you get to a green card even if you obtain this benefit. So it's something to consider if you're going to give up your DACA in this process. So in order to, but the goal with this thing is to help kind of improve the process of this waiver, because unfortunately you don't apply for this waiver in the country like you do the other one. You are going to be asking for this waiver when you're already outside the country. The goal is that it's supposed to streamline it and make it easier for you to obtain this waiver when you do go to an appointment. So we're still kind of waiting on some additional guidance to see how it works. But I think the clean cut case are those individuals that just only have unlawful presence potentially, or that illegal entry, and qualify for an H-1B visa. Because there are other non-immigrant categories that we could potentially consider, but again, we have to be careful when we're trying to send a DACA recipient outside the country. So now, what kind of questions should I ask, right? What are questions that I might consider? Do I need an employer to sponsor the green card? Yes, maybe not. Maybe you are a high achieving individual, you're top of your field, maybe you can self-sponsor. So again, we'd have to talk to an attorney to see if that's a potential option that qualifies you. Do you have to have a degree? Not necessarily. There's categories that don't require a degree. Of course, having a degree does help, and it helps for the non-immigrant options. Of course, a position doesn't necessarily have to require any skills. If it's just a position where marketing or recruiting is hard for it, then it's still, you know, your employer can prove that there aren't qualified U.S. workers, then it's still a position that can be sponsored through an employment-based process. Okay, things to ask yourself, ask your parents. Was I brought into the country more than once when I was a child? Do I have any prior order of removals? Okay. Can I still qualify? You know, we'd have to look at the case to make sure that is something that we can still overcome. And of course, questions to ask your parents, ask them about that prior petition. If that is something that they have, then your process would look so much easier. You know, you want to know how you're brought in the U.S. because, again, if you were ever detained and there's something on record about you, then you'd want to know before you expose yourself or consider leaving the country for any kind of process. And so next, we're going to talk about the family-based process, okay? Because sometimes this is maybe you come to your employer and you meet with us, and we're going to go through every scenario because we want to give you the best advice, and we want to make sure that we're going to take the easiest and fastest route for you, right? So we would still ask about all your family relationships, right? And in a family-based process, you're potentially dealing with more than one agency as well, right? If you have a previous removal, or you've been in proceedings, maybe we'll have to deal with the Department of Justice as well. If you're going to do consular processing, then we would also be dealing with the Department of State. But the big thing about DACA recipients and going through a family-based process, so let's say you have an immediate relative, but you are brought into the country without a visa. Um, um, and uh, and you want to be able to not have to go to an interview abroad. Well, there's a way that a DACA recipient can obtain a legal entry in order to do an immediate relative petition and adjustment of status in the US, okay? But I have to say that advance parole isn't just to benefit that one category. I think anyone should take advantage of obtaining advanced parole because we don't know how else this can help you in the future. Having obtained that legal entry could potentially lead to something else that you could potentially gain in the future, because immigration is a very it's a very political climate. Things change, things open up, things shut down, but we don't know when that could be helpful. So I always recommend, if that is as a possibility for you, definitely take advantage of that. Right now, it is a good time to do that before this election year ends. But in your reasons for taking a trip abroad can be have to be an urgent humanitarian type situation, but it can be business. It can be for your education. So whether it's traveling abroad to study, to work, for a conference, visit sick family members, it's important to try to take advantage of this. And try to take that entry to obtain that legal entry. Are there risks associated to this? It could be, but it's obviously important to talk to an attorney to make sure that wouldn't be a risk to you. But again, even if you have a old removal order that's sleeping, you can still travel abroad and do this advanced parole program to obtain a legal entry. Because once you do the legal entry, again, if you have an immediate relative situation, then you can adjust status and without having to leave the country. Again, not considering any other inadmissibilities that you may have. So just kind of scenarios, right? If you have an order of deportation, you could still obtain advanced parole. Of course, if you're seeking adjustment of status based on that legal entry, of course, you still have to kind of take care of that order of deportation. And it doesn't mean because you have it, then there's nothing left to do. No, we can still try to make a request to ask the judge to reopen your case and then terminate it, right? So obviously there's a whole analysis that we have to go to see if this is possible, but that doesn't mean that you shouldn't try if you have an order of deportation. Similar to something that if your case is administratively closed, you can still do the same thing. So this means that at some point you were in proceedings, but a judge never ruled on your case, and it's just kind of sitting in their docket, asleep, paused, not a high priority, but we would still want them to recalendar that case, put it back on their docket and dismiss it, so that way you can go on with your adjustment of status process. Now, let's say that we can't travel, we haven't found a reason, or we're afraid to travel with advanced parole, or it was denied. I mean, you would be forced to do consular processing in an immediate relative situation. Again, and if you don't have an immediate relative, no matter what, you have to do consular processing. But in a family-based process, there's also still times to consider, depending on the category that you fall under. Like I mentioned, immediate relative means there's instantly visas available for. There isn't a limited number of visas available for that category. But if you fall under the preference categories, similar to the employment base, there's a limited number of visas per category, and then it's also divided in by countries. So if you are a child of a US citizen, an adult child, we're looking at a very long wait. We're looking at waits for countries like Mexico or India, all of these countries. I think the fastest moving is actually India and everybody else, and they're in 2015. But if your spouse is a permanent resident, this is moving a little faster, but it's again also still delayed. And now if you have a US citizen sibling, these are even longer. So look at the dates here. For other countries, this calendar is a little old, but we're probably a few months to a year off as far as, because this changes every month, okay? So I know for Mexico right now, it's in April 30th, 2001. So it has progressed, but you're looking at over 20 years waiting to actually be able to complete your consular process. So what does that mean? If DACA already ends and you didn't have a lawful presence and you're still waiting for your adult citizen's petition to hit its priority date, then you're probably going to need a waiver, right? Because if DACA ends, you will begin accruing unlawful presence, unfortunately. Okay, so what are questions to consider when you're thinking about any family-based process? I mean, the same thing as you would in your employment base. You know, you want to disclose any kind of criminal situations, even if they're juvenile criminal, what they would be called juvenile delinquencies versus criminal, but there's still things that we have to kind of think, you know, analyze before we send anyone outside the country that could potentially be a reason for denial. And of course, no understanding any entries and exits that you had as a minor or as an adult, but you know, even as a minor, they matter, even if you're not accruing a lawful presence. Have you ever been detained? What were the reasons? What was presented when you were detained? Whether your parents were detained for you and did they present any documents? Do you have prior orders of removal or deportation, or a case that's been sleeping that maybe you don't know about? And of course, knowing, having copies of all of your DACA applications to be able to analyze, did you accrue or have you accrued any unlawful presence, okay? And of course, the last question that I get asked a lot in a consultation is, should I renew my DACA application if I'm in any of these processes? Yes, absolutely yes. You never want to stop renewing it if you still can, even if you already have a work permit based on an adjustment of status application that is still pending, because anything can happen. Anything can happen. And if you let your application lapse and it's lapsed for an entire year, you can no longer renew it. You have to apply for as a first-time applicant. And unfortunately, the government is not accepting first-time applications. So you want to keep renewing until the very last moment. All right, and so just again, a little bit about me. My name is Maricela Alvarado. I work for Monty Ramirez Law, and again, we represent employers and individuals. And of course, we just wanted to share more information about questions that DACA recipients should be asking and things that they should be considering in case that this program comes to end in the coming year. Okay. Thank you.